Hi, my name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case Strickland v. Washington. This case was heard in the Supreme Court of the United States in the year 1984. Let's go ahead and jump into the facts of the case. Mr. Strickland was the superintendent of the Florida State Prisons. Mr. Washington was a defendant in a criminal case. Mr. Washington confessed essentially to some pretty heinous crimes: murder, torture, rape, pretty terrible things. And he was prosecuted for these things. And essentially, he's found guilty for all the substantive crimes, and he gets to his sentencing hearing. And at his sentencing hearing, he has an attorney. And this attorney basically says, hey, I know this judge. This judge is into showing remorse. If you show remorse, there might be a chance you don't get capital punishment. That's kind of the best strategy I've got. That's what I've heard, is that the judge likes remorse. The attorney did not call the friends of Mr. Washington, nor did the attorney get any type of psychiatric evaluation of Mr. Washington. These would be types of things that would lead to mitigating factors for the death penalty, where you might have aggregating factors on the one hand, mitigating factors on the other hand. If you had enough mitigating factors, then maybe the judge would see that, hey, you know what, we're not going to sentence this person to capital punishment. It's important to note that it is just the judge in this case, because the defendant, Mr. Washington, waived his right to a jury at this sentencing proceeding. So sentencing goes forth. The judge sees a lot of aggravating factors and says, hey, you know what? I feel bad about this, right? But we're going to have to sentence you to death. What you did was especially heinous. It was terrible. And there aren't really any mitigating factors that weigh in your favor. And so, yeah, you've shown that you're remorseful, but that's not enough to outweigh all of the heinous acts that you committed. And these murders and rapes and tortures. And so sorry, but yes, we're going to sentence you to death. Well, Mr. Washington is not done. Obviously, he wants to fight for his life. And so he appeals to the federal courts. And eventually this case bubbles its way up to the Supreme Court. And so the Supreme Court has to decide, what does ineffective assistance of counsel look like under the Sixth Amendment? And so the idea is that the Sixth Amendment guarantees counsel, right? And so that's why you've seen, maybe if you watch a TV show, if you've been in a court where you're told that, you know, you have a right to counsel, and if you can't afford one will be appointed for you. But you also, the court says, basically, you have a right to effective counsel, not just any counsel. You don't have the right to a sleeping lawyer. No, you have the right to a awake lawyer, one that's willing to help you and do what needs to be done to move the case forward. And so the court has essentially read effective counsel into the Sixth Amendment to make the system work. It discusses, the court does, that the adversarial system depends upon effective counsel, because if there's not, then the two sides won't really be able to debate or advocate for themselves in a way that makes it surer that we'll get to the truth in these types of trials. And so that's where we're at. We're in a criminal trial, and this is the Sixth Amendment. Well, the defendant wants to argue that the counsel that he received was ineffective, right? Because there weren't any of these mitigating factors put on in his sentencing hearing. Nothing about his character, nothing about the people, his family or friends that wanted to discuss his character, nothing about a psychiatric evaluation and those types of things. And so this defendant is fighting for his life. And so the court has to come forward with a standard. What's the standard? Well, the first, it's two prongs to state a claim for ineffective assistance of counsel. First, you have to show that the attorney's performance was deficient. And then second, you have to show that deficiency prejudiced you in a way that, but for that deficiency, you would have a different outcome. So let's dissect both those factors, right? So the first is that the attorney's performance was deficient. Well, the court says this is a reasonable standard. And the court doesn't lay forth some bright line rule for every type of case and every type of controversy and what this might look like. But the court says this is a reasonableness inquiry, where we're going to allow the courts to look at this and say, was this strategy reasonable? And persuasively, the court says advocacy essentially is an art. It's not a science. And so lawyering can take many different shapes and forms, and we can't judge that against, some platonic form of lawyering. No, it's an art, and each advocate has their own skills, and so the judge is going to look to see what's reasonable. At the same time, the court carves out two things that say, well, this isn't going to be effective assistance of counsel, just categorically. The first is no assistance, right? So if the attorney just doesn't do anything, well, okay, then you've said that that was not that performance was deficient. And then the second is where the court says if the attorney had a conflict and they didn't disclose that conflict or do anything about it, well, okay, then you have deficient counsel again. All right, so that's the first prong. The second is essentially this but-for test that the defendants need to show. They have to show that but for this lawyer's deficiency, the outcome, there's a reasonable probability that the outcome would be different. And so that essentially is putting the judges into a role where they're going to have to judge, kind of using hindsight in a sense, would this have really changed the outcome? The burden is on the defendant to look at this and to try and argue that the outcome would have been different. And so you can really see that that second prong is a very high bar to make judges look back into the crystal ball, back in time, or see what the world would have been like if there would have been different actions. It's really hard to do, and judges might be hesitant to do that altogether. So how does this rule apply to this case, the Washington case? Well, the court says this was a reasonable advocate doing what a reasonable advocate might do in this situation. Yeah, this guy had confessed to the murders. He's on the hook. It doesn't look good. Nothing looks good here. And so this advocate knew that the judge was friendly to remorseful defendants and said, hey, you know what? That's probably our best shot here. So let's just go with that. And so, yeah, that was a reasonable move of advocacy. And also the defendant couldn't really prove that, had these character statements got in or had a psychiatric evaluation got in, that the outcome would have been any different. These were heinous crimes and these were terrible things. And so, yes, that's what the court says is, yeah, here's the standard, and Washington, sorry, you didn't meet it. There's a concurrence by Justice Brennan where he just goes off and says he thinks the death penalty is unconstitutional. And then there's a dissent by Justice Marshall where he says that this standard is just a little bit too squishy. And it puts lawyers in position, or excuse me, it puts judges in positions where they're going to have to basically use their intuition and look into that crystal ball and try and figure out what was going on. And that is just really kind of too hard in a sense for these judges to do. He doesn't like that this is such a squishy standard and it's such a high bar for defendants to meet that really the Sixth Amendment doesn't have much teeth. Neither does the ineffective assistance to counsel claim. That's essentially Justice Marshall's critique in his dissent. So this is really an interesting case to think about is, was this bar set too high? And if it was, how could this be changed? I mean, it's easy to say that this isn't a good move by the court, but it's harder to see what the solution might be. What could a world look like where the judge doesn't kind of have to intuit would the outcome be different? Would we have a world where there's endless appeals and, essentially people are going to argue ad nauseum that their counsel was ineffective, and what are the costs that imposed on the system? And so that's the case here. Thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.